He is a chairman of a municipality. He can get what he can do. He cannot come to the court. He is the person who was in charge of the parliamentary constituency election of Boycott. He has conducted the election, but he cannot come into the court. 70 years. And incidentally, I am 69 years.
So, আপনার অনেক এনার্জি আছে। You are young and youthful.
He is more youthful and colorful man more than me. You do not know. I am telling you. Fortunately, I know everyone and history. History, geography, everything. More colorful and more you cannot be. 2017 to 2025, 8 years have gone. 8 years have gone for concluding the evidence. Because openly saying, in your life you will not get divorced.
This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
I will read below. I will come back there. I am showing you one. One is a compulsory. If you comply one, then the below other things comes. Summoning one subgroup, two subgroup, and one. It comes. First you comply then. You have not complied. For that reason, court's order is not required. You are blaming the court. Good. What duty you have done it? First show.
Yes.
Mana now come. 7th August 2000. The date was fixed for further DW. Defense witness. You come. That is one. That is one. Come. No steps were taken by the defendant. Again, the defendant failed to file them. Now, therefore, 7th August 2024 was fixed for examination of the witnesses. You did not come with any of the witnesses.
7th of August.
Yes. 7th of August. 27th. Oh, sorry, it is 27th August.
27th, yes.
27th. I'm sorry, 27th.
Yes.
27th August. It's not, sorry. 27th.
Yes.
Now, can you read now with this one? Come. One has to interpret in the facts of the case. Read one. Subject to the provisions of sub-rule 3 of Rule 1, any party to the same may applying for some under Rule 1, bring any witness to give evidence or to produce documents on which date. Date fixed on the next date. Not on the basis of the date which will be chosen by any of the parties.
Date fixed by the court.
But you come. Why you didn't come? If you thought my brother is a very important witness for you, come. He is banking on my brother's witness and my brother's relative's witness. My relative's witness. I'm not, we are all aware in a society where we live. There are good relationships, there are also bad relationships within the brothers. If you are very important, why should I give in it? You see, therefore, 1A is not applying here in this case. Because on 27th August 2024, he did not come with the witnesses for which the list has been given. What kind of thing? Today is fixed for further DW.
193. Give me a minute because some orders have been.
27th August 2020.
So, Bachat, your in the application order number 193 has been annexed.
My lord, 193. I'll just
193.
My lord, I have it here in case your lordship wants it.
No, if it is annexed, then I will go through that because otherwise here and there. Annexed.
It's not annexed. It's not annexed.
Not annexed.
Now, let me read this order. Today is fixed for further TW. Petitioner Shobhan Chatterjee is present by filing Hajira. No step is taken by the respondents to wife Srimati Ratna Chatterjee. Learned advocate for the submit that although this court repeatedly has given direction to file the list of witnesses and to start the copy of examination chief of the witness in advance, but the respondents wife did not comply the order of the court and as necessary orders may be passed. On repeated calls, learned advocate appearing on behalf of the respondent and submit that the witness as well as could not come and accordingly has paid for passing necessary order in view of the register of local party. Advocate did not come. Why your witness did not come? My client was there. My client's advocates were there. Therefore, Lord, 1A, even for the argument's sake, if I say, Lord, applying for argument's sake, although I have a different argument, 1A applying, that was exhausted on 27th August. And you see the next order, 6 September 2020.
Yes. Yes.
Today is fixed for further DW petitioner Shobhan Chatterjee is present by filing Hajira. Respondent wife Srimati Ratna Chatterjee is present by filing Hajira. No witness is present. See. And he is a member of Legislative Assembly 70 years. He can come to the assembly. He cannot go to the argument. He is a chairman of a municipality. He can get what he can do. He cannot come to the court. He is the person who was in charge of the parliamentary constituency election of boycott. He has conducted the election, but he cannot come into the court. 70 years. And incidentally, I am 69 years.
Sir, আপনার অনেক এনার্জি আছে. You are young and youthful.
He is more youthful and colorful man more than me. You do not know. I am telling you. Fortunately, I know everyone and history. History, geography, everything. More colorful and more you cannot be. At the first, at the stage of order 46, rule 1.
Order 16.
Order 6, sorry. Order 16, rule 1. Discretion rested with the parties. 18, 20, 25, 30, 100. 2. The court has 3. The court may reasons to be recorded permitted party to call whether by some.
3 is outside the list. 3 is outside the list.
Outside the list.
3 is outside the list.
3 outside the list and 1 at
that stage, yes.
Then 4. 3 was at 4, then 1. This is some any party to the suit may without applying for someone to bring any witness.
That's
right. 1 is this his discretion. If the court rejects, then the other questions come. This is not complex. Court has given repeated time hereafter also. Give the list of witnesses. No. DW1 completed, DW2 completed, then submitted an application, 18 to 20 witnesses. Nothing, no names, nothing, rejected. And other day, when DW2 has completed, and the next day, no witness was brought. 1A exhausted. 1A cannot be kept for till doomsday. Then 2 witnesses have been allowed. Rest were not allowed, not challenged.
No, that is he is challenging. From the list. From the list.
I'm coming. From the list, you are allowed.
Rest 5 not allowed. That is he is challenging now.
Come to order. No. That is not under challenge. Page 145.
145. Order number 200.
Order number 200.
Yes.
On perusal of the list of witnesses in the seal cover list of witnesses. Really, I have never heard it. Very important person, member of Legislative Assembly. How can I give it in the open door? Seal cover. We have also not seen because it is seal cover. It is on the list on the seal cover. It reveals that there are 7 witnesses which the respondent intends to adduce. Out of the 7, one Dulal Chandra Das intends to depose in this case on place of the earlier order. This was the respondent to the TW3, but that should be Dulal Chandra deposed on the next TW3 and thereafter on council of evidence. Subhash Das will tender his evidence as DW4 on further fixed by the court. On the other earlier occasion, to have this one was quite understood, taking into consideration the interfactor is totally the prayer of addition further evidence by the respondent. Why it is thereby allowed that Dulal Chandra Das deposed as TW3 on the next date, keeping the litigation passed by the to expedite them if the next day for transfer. Parties are hereby directed. Therefore, by this order, court has made clear DW3, DW4. This order has not been challenged. DW3, DW4 has not challenged. Now let come DW3 and DW4, but I mean Dulal and other have been examined. Therefore, he has accepted that order. He has accepted Dulal Das and another one. How we can challenge witnesses? 5, only the 5, the other 5. She has accepted the order itself. Yes, Dulal Das and another one will be examined. Now, after this again application, I have given 7 names who have been allowed. And this is the list your lordship has seen. And repeatedly it was said that this illicit relationship with this gentleman I have not. No, with this gentleman. This is come. OB is Moistro. No. Let him show.
From the list.
Some other's name is there, not the Obijit Moistro.
His name is not in the pleadings. Yes.
3 Millard, 1 and 2 allowed.
1 and 2 allowed.
That order. Then on that, thereafter, can any party enjoy the fruits of an order, one part, after enjoying it, can he challenge? Whether it is stopped, was because of doctrine of the stoppel itself. After the case comes, absolutely afterthought only to delay the proceeding. Number 3, my cousin brother. Number 4, I am not no allegation. But if I cannot prove the illegitimate relationship,
your suit will fail.
What is this? What for? She will come and she will say, no, I am not. I am not. Then I have to find out other person.
Yes.
Then why? Brother of the petitioner, why? Why? suspicious. Now it is suspicious. From 2017 to 2025, 8 years have gone, it is suspicious. Then Millard, 6, cousin brother. Fortunately, no cousin sister, daughter-in-law. Others are not there. Why you have not brought them? Why not the Jaz and Nonods? They will tell everything correctly. Then Millard, 7, distant material uncle. Maternal uncle. Distant maternal uncle.
That Mr. Bachawat says he may not press for this.
No.
Mr. Bachawat, is it your
He has
7?
But he has made the allegation against him in his evidence. He has made the
So
allegation.
are you pressing for 7 also? Because in course of your argument, you said
I said they may not be that important. I can take that.
No. Now, point is this, Millard. I have made an allegation against someone. If I cannot summon them,
Yes,
it should not be proved.
6 and 7.
6 and 7, you are not insisting.
Case is not proved.
But
But
sorry, but just answer to the gotcha. So as far as my lord, as far as 6 and 7 are concerned, I can show your lordship not in his written statement to the counterclaim and in his chief.
Whether you wish to or you do not
But
intend to.
if your lordship intends for the sake of not shortening it, I could not say that we will not.
All right.
no.
Yes.
Not me. But can you see? If I have said referred any names, allegations have been made. Pardon of proof is essential. Why he is worried about my pardon of? And if you are interested to bring them to speak against me, why did you not file the list of documents earlier? Another list of documents. Another part of lordship has consider. When your lordship should consider route 1, consider now. How I will proceed? I am the plaintiff. How I will proceed? Plain, written statement, list of witnesses, documents disclosed. I have to proceed on that case. If someone wants to bring another one, how will proceed? Everyone has to proceed. Right is only him. His right. My right is not there. My right to avail the opportunity to beat the case at that point of time will be taken away. Will be taken away. I have to beat the case. I have to put my case. After knowing fully well what are the materials are available. At the end, you will bring it how I will do it. My submission with your lordship on the point of law is there. Opportunity to just I'm framing the point. Opportunity or chances to bring the case before the court has to be given to the plaintiff. And before the examination is started, everything should be disclosed, otherwise I will do it after finishing my cross-examination.
So according to you, this list of witnesses ought to have been produced or submitted prior to starting of the evidence. Your evidence, because
yes, even although it said 15 days from the date of settling the issue, let it be
it may be extended.
Court is having decision. I have no objection. Court is time extending. All of a sudden, someone is brought. How can it fail? What is the chances? Would it be an unending litigation? And nobody should take that court proceeding is a maternal uncle's house. Anytime, every time, whenever I like, I will do it. Therefore, discipline has to be enforced by today. by your lordship, by fixing, by laying down the law. Everywhere, proceeding everywhere, a party should be disciplined. Not rule of reading, rule of practice, rule of procedure, rule of, it is not just an empty thing. Therefore, it has to be seen in how we have access. I would have made up my case also. Why your lordship asked that? They exchange the documents, exchange the entire thing. Well, I should know. All of a sudden, someone is brought. This is not also not rule one. Although Supreme Court, I will read here. I will read that judgment, particular that portion. That doesn't mean that such a discretion power. It is an unfettered discretion power. Unfettered discretion power. It cannot be. And it was not the object of the court. Not a single court has any. Court can see, court can look. Let me tell you, very court can see. No, his conduct is correct. Everything is doing well. Everything is going good. This is the witness case. But a discretion is very, very important for the case. But a matrimonial matter was the prime witnesses, husband and wife. Personally, they have seen the relationship in the closed door. Any witness is there?
Yes.
If this word is here, in court proceeding, you can understand what my client has faced in his life. In each and everywhere, each and every place, every step I am giving objection. Every step I am giving objection. No, I need a quality of life now. I am really tired of. I am really tired of. If the proceeding is there, I have given my evidence, everything. How I have spent my life, I know.
Yes.
A quality of life is needed for me today. I am also aging here. I am also 65 in my time. How long this world will continue to tell me? And do you think, let's leave aside, do you think that after this, even the business suit is this way, there will be an activity? My humble submission is, who is entitled to get a relief? Although it's a civil litigation, a person who has come with a clean hand, clear in mind, a person who is delaying the proceeding, times and again. What is the object of this matrimonial matters? Very quick, this was 2017 to 2025, 8 years have gone. 8 years have gone for concluding the evidence. Because openly saying, in your life you will not get divorced. That is it.
Yes.
Can I allow Mr. Court?
Yes, yes. New Act or the old Act?
Old Act.
Old Act. Evidence Act আছে?
Oh, yeah, I have a copy.
পেয়েছেন ওটা নয় yes yes Mr. Kaur.
Lord, if your lordship kindly takes three sections, 134, 135 and 136. Because my learned friend's contention relying upon this judgment is Order 16, Rule 1 is sacrosanct. And Lord, if he wants to produce, Lord, any number of witness,
At any point of
at any point of time, the court is bound to allow that. Lord, kindly come to section 134, 135 and 136. These are the three sections. 134 says, no particular number of witness shall in any case be required for the proof of any fact.
Called on next day.
130, I'm sorry.
accepting this সেটা বলে দিন
Accepting this.
Lord, I have taken care, you know, Lord, can take up that matter, that environment matter on Monday. Don't, I have taken. But I will argue the matter. But
Yes,
up to until your Lordship hears the matter, things should be all right.
তাহলে ওইটাতে না
Not,
then